What's the single biggest mistake Canadians make when they get pulled over by the police? Honestly, it depends, but most people get this wrong, and they get it wrong in the same two ways almost every single time. And here's the thing, the mistake usually isn't refusing to cooperate. It's the opposite. It's saying too much and handing over rights you didn't even know you had. So in this video, I'm going to walk you through two real situations. Situation 1, what you actually have to tell an officer when you're pulled over versus what you should keep to yourself. Situation 2, what happens when an officer asks to search your car and the exact words that quietly give away your protection without you realizing it. I'm going to give you the real Canadian law behind each one, the actual section numbers, and the exact words you can say out loud. Let's get into it. Picture this. You're driving home. You see the lights in your mirror. You pull over, you roll down the window, and the officer leans in and says, "Do you know why I pulled you over? Where are you coming from tonight?" And here's where I see people make this mistake all the time. They start talking. "Oh, I'm coming back from a friend's place. We had a couple drinks, but I'm totally fine." They think being chatty and friendly makes them look innocent. What it actually does is hand the officer evidence for free. So let's separate what you're legally required to do from what you're not. If you are the driver of a vehicle, you do have to identify yourself and produce your documents. In Ontario, for example, this comes straight out of the Highway Traffic Act. Section 33 says every driver of a motor vehicle shall carry their license and shall surrender it for inspection when a police officer demands it. And if you can't produce the license, you have to give the officer your correct name and address. Every province has its own version of this in its own traffic legislation. So this part isn't optional. License, registration, and proof of insurance when you're driving. That's the law. Now here is a common misconception. A lot of people believe that because you have to give your documents, you also have to answer all the officer's questions. Where were you? What were you doing? How much did you drink? That is not the same thing. Identifying yourself as a driver and answering questions about your night are two completely different things. Your protection here comes from the Charter. Section 7 of the Canadian Charter of Rights and Freedoms protects your life, liberty, and security of the person. And the Supreme Court of Canada has recognized that this includes a right to silence and a protection against self-incrimination. You generally do not have to explain where you've been or what you've been doing. You provide your documents. You're not required to narrate your evening. Now, one really important and honest caveat, because I will not oversell this. There's a specific law that is an exception. Under Section 320.27 of the Criminal Code, Canada now has what's called mandatory alcohol screening. Since 2018, if a police officer has lawfully stopped you while driving, they can demand a roadside breath sample on an approved screening device, and they do not need to suspect you've been drinking. If you get that demand, refusing to blow is itself a criminal offense. And just so you know the full picture, the Supreme Court in R.V. Thompson held that at that roadside screening stage, your right to call a lawyer is temporarily suspended for that quick test. So this is not the moment to refuse or to argue. You blow, but answering chatty questions about your night? That's different. So here's your exact phrase. When the officer asks where you're coming from or what you've been up to, you can hand over your documents and calmly say, word for word, "Officer, here's my license, registration, and insurance. I'd prefer not to answer any questions, and I'd like to speak to a lawyer." That's it. Polite, cooperative on what the law requires, silent on what it doesn't. You're not being difficult, you're being precise. Here's the second situation, and this is the one that costs people the most. The officer's been talking to you for a minute and then says, almost casually, "Mind if I take a look in your car? You don't have anything to hide, right?" And here's the mistake. People say, "Yeah, sure, go ahead." Sometimes out of nervousness, sometimes because they genuinely think saying no makes them look guilty. But the moment you say sure, something legally important just happened. You consented, and consent changes everything. Let me explain why. Section 8 of the Charter protects you against unreasonable search and seizure. As a general rule in Canada, the police need a lawful basis to search your vehicle, for example, a warrant, or reasonable grounds, or certain situations connected to a lawful arrest. They can't just search any car they feel like searching on a hunch. But, and this is the part people miss, you can waive that protection. If you give consent, the officer no longer needs that independent legal justification because you handed it to them. That's why, "Yeah, go ahead," is such a costly little phrase. You may have just turned a search they couldn't legally do into one they now can. Here is a common misconception worth busting. People think that refusing a search is the same as admitting guilt, or that the officer can punish you for saying no. Declining a search is you exercising a charter-protected right. It is not, by itself, evidence against you. Now I want to be straight with you, because the accuracy here matters. Saying no does not magically stop every search. If the officer already has their own lawful grounds, they may be able to search regardless of what you say, and whether those grounds existed gets sorted out later, often by a judge, not by identify you on the side of the road. And the precise rules around vehicle searches can get into gray areas that depend on the exact facts and can vary in how they play out. So if you're ever actually charged after a search, that's a conversation for a lawyer, not something to settle by arguing on the roadside. What you should never do is physically resist or try to block the officer. That can become its own criminal problem. The move is verbal and calm. You make your position clear, on the record, and you let the lawyers sort out the legality afterward. So here's your exact phrase. If you're asked to consent to a search, you say, word for word, "Officer, I do not consent to any search. I'm not resisting, but I do not give my permission." Say it once, say it clearly, then stop talking. You've now made it unmistakable that anything that follows was not consented to, and that single sentence can matter enormously if your case ever sees a courtroom. So let's bring it home. The biggest mistake Canadians make when pulled over isn't being uncooperative. It's volunteering things the law never required them to give up. Here's how you avoid it, in 3 points. Number 1. As a driver, you must hand over your license, registration, and insurance. That's required by your province's traffic law, but Section 7 of the Charter means you generally don't have to narrate your night. Number 2. Roadside alcohol screening under Section 320.27 of the Criminal Code is the exception. If you're lawfully stopped and you get a breath demand, you blow, because refusing is a crime on its own. Number 3. You can decline a search. Section 8 of the Charter protects you, but consent waives it, so don't hand over what an officer might not otherwise be allowed to take, and never physically resist. Save this video so you've got these exact phrases when you need them. See you in the next one.